This is a Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. And what we're talking about is estate planning do's and don'ts. So in the previous section, we were talking about the last will and testament, on having a properly executed document. That downloaded document you get off the web to quote save money could actually end up costing you your plan of distribution. What I mean by that is you download the document, you sign off on it, you think it's a valid last will and testament, and lo and behold, you pass away, your surviving spouse takes that to the probate court, and the probate court judge just shakes his head and says, invalid will, law of descent and distribution applies. Therefore, wife, you're going to get half, and the other half is going to be split among your kids. Have a nice day. Gavel slams down. That's the way that works in the probate court. It is very succinct on what needs to be in your last will and testament to be a properly executed document, and therefore it is determined to be a valid will. So again, wake up call for our listeners here on the Professional Edge. If you've downloaded that last will and testament, or you have word sourced with this AI and you do not properly execute that document, then it is not going to be able to be proved to be a valid will. It's going to be set aside, and therefore the law of descent and distribution in the state of Georgia or your domicile state is going to control the distribution of your estate. Not the most useful effort on your side. So again, let's not have that happen. Let's simply sit down, have a conversation, get your decision makers, get your plan of distribution, and identify how much, to whom, and when they're going to receive that. Execute it properly, and then that way you have peace of mind that you have a last will and testament or an estate planning document that actually defines who's going to get your stuff and when. Now, am I a proponent of last will and testaments? The answer is no. If you've listened to the Professional Edge, I think there's a better way. I think that is like a horse and buggy to play in your estate. And in the later sessions about estate planning do's and don'ts, I'm going to cover the better vehicle, and that is a living trust that you're going to have, or an inter vivos trust. So stay tuned on those. So back to this last will and testament, you can have this identify your guardians of your minor children. But what is the other estate planning do's and don'ts? Well, do have some sort of durable financial power of attorney. What is that document? Well, there are two types. One is a durable financial power of attorney, and one is a regular financial power of attorney. Let's go with the easy one first, the regular power of attorney. If you're going to be out of town and you have some business dealings that you need to complete, you can do a financial power of attorney to your friend or your agent, and they can complete that transaction when you're out of the country, and it can be a specific power of attorney. So therefore, it is dealing with, as we called it, Blackacre in law school. You are going to be out of town and they need to buy this on your behalf. So therefore, we have a specific limited power of attorney, so they can transact any and all business with regard to Blackacre. But as soon as Blackacre is conveyed and purchased, then that limited power of attorney terminates. So that's one way. Now, with a regular financial power of attorney, if you become mentally incompetent, Alzheimer's sets in, then that power of attorney becomes null and void. It wasn't properly drafted. So again, you're downloading these documents, trying to be on the cheap, miserly. Well, it's going to end up costing you, because when that document gets set aside and your agent tries to start paying your bills, then the attorney at the bank is going to look at that and they're going to say, sorry, Bill Smith became mentally incompetent and he appointed his best friend Tony. Tony's not a valid agent because this is not a durable financial power of attorney. This is just a simple power of attorney. Therefore, it's null and void. So guess what? The friend or the family gets to go to probate court and petition for a guardianship over your property. So that's involving attorneys, involving the court, and that is a lengthy process, probably anywhere from $3,000 to $5,000 in attorneys and court costs to get that done. So let's step it up and get a durable financial power of attorney. That is a properly executed document which says, I appoint Tony to be my agent, and this power shall survive my mental disability. It's proper legal language. It's in there. It's very succinct, very technical on that. And therefore, when you become mentally incompetent, your agent, Tony, can continue to operate. That's the type of document you need. So that is an estate planning due. You want a durable financial power of attorney. Now, why do you have this power of attorney if you have a last will and testament? Well, the last will and testament only deals with your property when you have passed away. This is, I'm still alive, but I've lost my marbles, and therefore somebody has to make these financial decisions for me, whether to sell the house, move me into an assisted living or some long-term care facility. So they have that power. Last will and testament, you can appoint them and they can take that document, and it is ineffective on doing this while you're still alive. So we have the durable financial power of attorney as another part of our estate planning due. You got to have this document as part of your estate planning document set. So that's the other one. So have a durable financial power of attorney. So if you only have that last will and testament, you don't have a durable financial power of attorney as part of your estate planning documents. That right there is the impetus to give our office a call at 877-654-9798. That number again, 877-654-9798. We can also schedule a Zoom call, keep you from fighting the traffic in Atlanta, or our second office in Columbus, Georgia. So on to the next estate planning due. You want some sort of advanced healthcare directive. Some people refer to that as a living will. Yes, it's the same document. They give it multiple definitions or titles. What is referred to as the advanced healthcare directive. So with that, we have the ability to say who is going to make my medical decisions when I am not mentally competent to do so. So with that, I could be in a severe auto accident, have a brain injury, I'm unconscious, and the doctor wants to know if they can do some surgery. Well, family member could be there, and they could say, well, do you have an advanced healthcare directive? And the person says no. Then the doctor is going to go to their standard of care to care for the person involved in that automobile accident. But then the more technical details, then the hospital is going to turn to and say, look, you need to petition the probate court to get an advanced not an advanced healthcare directive. You need to petition the probate court to get a guardianship over the person. That will then allow you to make healthcare decisions for the person in the hospital. Again, lengthy process. It's an expensive process when it can all be handled by having an advanced healthcare directive in place. So that also addresses that last stage of life, whether you want nutrition and hydration to be continued or discontinued when you are, let's say, in a persistent vegetative state, or you're in a terminal condition. Those are two of those conditions that apply. You get to make that decision so you're not placing that burden on a family member. So again, an estate planning due, got to have either a last will and testament or a revocable living trust. That's number one. Number two, you need to have a durable financial power of attorney. And then number three, your advanced healthcare directive. That is the foundation of any listener here on the Professional Edge. You have got to have these three documents. And if you have one of the three, that's the impetus to give our office a call to get that straightened out and taken care of. If you have that big, thick placemat paper, you could use it as wallpaper as well, then that is also another sign that you need to update your estate plan or at least have it reviewed and looked at. So that is the estate planning do's that you need to do. Now, the other thing on an estate planning don't neglect looking at the titles on your assets. What do you mean by that? Well, there are certain things that supersede whatever you have in a trust or in a last will and testament regarding the distribution of your property, and that is the legal title on property. Real simple. We see individuals that get older and they start doing napkin estate planning. So they add their son or daughter to their bank account to pay their bills. Well, guess what? When they pass away, that account title supersedes whatever they have in their last will and testament. So let's say in their last will and testament, they said split everything equally between my two children. Well, when they added the daughter to that bank account because she lives in town with them and the son is down in Florida doing whatever he's doing, he's living there. When that joint account holder dies, guess what? The other joint account holder supersedes to 100% ownership. So the bank account is not going to be split equally between the two kids pursuant to the last will and testament, because the title on that bank account will supersede whatever provision they have in their estate planning document, be it a will or a trust. So therefore, that's an estate planning don't. Don't do napkin estate planning, because you also have just exposed the asset of mom and dad by adding daughter to that bank account to the creditors of daughter. Now, let's fast forward a little bit. Daughter's relationship with her husband is not that stable. And lo and behold, there is a divorce filing with daughter. Well, you know what? The assets that she has to be claimed on the marital balance sheet. And that is that joint account with mom and dad. Yes, that has to be disclosed. She has legal entitlement to that account. She can access that account. And you say, wait a minute. We only put her on there just because we want her to be able to have access to that account just in case something happens to us. Well, by adding her to that account, that's the estate planning do not, a don't, because that exposes that account to the claims of the creditors of the daughter. So that is a estate planning don't. I appreciate your time and listening to The Professional Edge. My name is Sean Todd, tax attorney, CPA, and certified financial planner. I can be easily reached by calling my office at 877-654-9798. That number again, 877-654-9798. More coming up here on The Professional Edge.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the Professional Edge. Sean Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with Sean, call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Sean Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Scene is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Scene Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach Estate Management Counselors and speak with Scene Todd by calling 1-877-654-9798. That's 1-877-654-9798.